News Now Web Extra.
I am a professor at the University of Nebraska College of Law, and my focus is constitutional law. So I teach classes on constitutional law, and my primary area of research is constitutional law.
Did you have an opportunity yet to read the draft opinion?
I read a good amount of it. It's 98 pages, and I have to admit I haven't read the whole thing yet, but I've read enough of it to have a pretty good sense of what it says.
What was your initial reaction to it?
You know, it's not terribly surprising. Obviously, the big takeaway is that, well, one thing to keep in mind is that it's just a draft opinion, and sometimes justices switch their votes before the final opinion is issued. Obviously, that might not happen here. I think it's probably unlikely to happen here, but it's not the decision of the court yet. So that's important to remember. Obviously, the big takeaway is that if this opinion is issued, it overturns Roe v. Wade and Casey v. Planned Parenthood, and thereby returns the issue of abortion to the state governments. So in other words, there would no longer be a constitutional right to abortion. It would be up to each state to legislate as to whether abortion is permissible or not.
Would you explain the intersection between Roe v. Wade and privacy, which I think is where, you know, I wasn't alive yet, candidly, in 1973. But, you know, best a lot of folks are doing today is trying to truly understand what Roe v. Wade decided. So I'd like your take on privacy in particular.
Sure. So, you know, the right to abortion is nowhere specifically mentioned in the Constitution, but the Supreme Court has had a relatively long practice of reading rights into the Constitution that are not explicitly there. And a few years before Roe was decided, the Supreme Court issued a decision that struck down a state law prohibiting contraception. And that was a case called Griswold. And part of the court's reasoning in that case was that forbidding contraception interfered with the right to privacy. Now, the right to privacy also is not explicitly mentioned in the Constitution, but in Griswold, the court said lots of different rights that are in the Constitution relate to the right to privacy, and therefore it thought there was a right to privacy that this contraceptive ban violated. So when Roe was decided, the justices needed to link Roe to something already existing in constitutional doctrine. And because that right to privacy was there from a few years earlier in the contraceptive decision, that was the link the court made. I think since Roe, even a lot of commentators who were sympathetic to the outcome in Roe thought that privacy is probably not the best way to think about the right to abortion. And in 1992, the court decided a case named Casey that reaffirmed the basic right to an abortion, but grounded it in a somewhat different theory. In Casey, the court rooted the right to abortion more in what you might think of as decisional autonomy. In other words, the ability to make important decisions about your body and reproduction for yourself. And it also rooted it in women's equality, the idea that if women are to have true equality, they need to have control over their own reproduction. So it's correct to say that Roe v. Wade initially was decided at least partially under a privacy notion, but the right to abortion since Roe has sort of evolved and is linked less to notions of privacy and more to this idea that the government shouldn't interfere with these kind of very intimate personal decisions.
Is it right for folks to be concerned today about some of these other issues, whether it's same-sex marriage, contraception? I've been reading about internet privacy. What this opinion, if it does take a similar form, ultimately is what this draft feels like, if the spirit's the same. are those folks right to be concerned?
Well, the court in the opinion does call into question, I think, the validity of some other important Supreme Court doctrines. So, for example, when the court says that Roe really isn't connected to some of these earlier Supreme Court cases giving particular rights, it's very careful to say, to limit that part of the opinion to talking about cases decided before Roe. So, cases like Berger fell, which found a right to same-sex marriage, and Lawrence v. Texas, which struck down a Texas law criminalizing same-sex sodomy, the court seemed to leave open a possibility that it might be open to reconsidering those kinds of decisions. So I think it is theoretically possible that this decision would leave open the door to reconsidering those kinds of issues. I do think one major difference is, the issue of abortion is deeply divisive in America. And, now almost 50 years after Roe, Americans are still really divided over abortion. So to that extent, the court's decisions in cases like Roe and Casey, didn't quiet the debate. In other words, it isn't like Americans looked and said, oh, the Supreme Court decided this, we're going to stop fighting about it. They were still fighting about it. By contrast, in the area of something like same-sex marriage, demographically speaking, more and more Americans favor same-sex marriage and don't have a problem with it. Obviously, not everybody, but it doesn't seem to divide Americans quite as much as abortion does. And moreover, the trend has been continually in favor of more and more people favoring same-sex marriage. So I think it would be more surprising if the court were to overturn its decision on something like same-sex marriage, just because that decision would seem to be at odds with demographic trends. Whereas, again, abortion has been dividing people a lot. But I think the people who are speculating that the court's decision, or Justice Alito's opinion, if it does become the court's decision, would open the door to possibly revisiting other areas, are correct about that.
I did want to ask you, because I know you worked in DC and you clerked for Merrick Garland in a past life. Just from your point of view, the surprise of a leak like this occurring, it just seems, I can't, at least I haven't heard of any examples where something similar has happened previously. If you could put that in context.
Yeah, I think this is very unusual in the contemporary court. And I would imagine that Chief Justice Roberts is outraged that this leak occurred. It's very, very unusual. I think the most prominent case I can think of a leaked decision in Supreme Court prior to yesterday was actually the Dred Scott case back in the 1850s, which involved slavery and was really a momentous decision, and a decision that some people think helped lead the way to the Civil War. And there's widespread speculation that President-elect Buchanan knew the outcome of the Dred Scott case before it came out, which enabled him at his inauguration to say he would cheerfully submit to whatever the court decided. And I think there's a lot of historical evidence that he, in fact, knew what the court was going to decide. So it's not unheard of for a major Supreme Court opinion to be leaked beforehand, but it is very unusual. And I can't think of another instance of that occurring, certainly during my career as a lawyer.
How might that happen? I've heard about clerks, for example, eating in like glassed in areas so that they aren't around visitors at the court, that there's just this, quite a bit of protection around them. You don't imagine that the justices would have done it. So do you have any thoughts about how it occurred?
It's hard to know. I mean, I think a lot of people think the clerk that a clerk is probably the most likely. It's possible a justice might have done it. You could imagine either a clerk or a justice who didn't like the outcome in Alito's opinion disseminating it, or possibly you could imagine someone who did like the outcome disseminating it in the hopes of persuading all of the justices who had tentatively said they would sign on to the opinion to stay signed on to the opinion. So, a little bit of history here. I referred earlier to the Casey decision in 1992, which reaffirmed Roe. In that case, a lot of observers expected the court then would overturn Roe. And in fact, the initial vote at the Supreme Court appears to have been to overturn Roe v. Wade, 5-4. And then after the initial draft was circulated, Justice Kennedy, who initially had decided to vote to overturn Roe, thought about it some more, changed his mind, and decided he wasn't going to vote to overturn Roe. So what had been the majority opinion then turned into a dissent. So I think a lot of people are thinking that Justice Alito's opinion was an opinion for 5, for himself and 4 others. So it's possible that one of the conservative clerks leaked it to try to pressure all of the other justices who had signed on to Justice Alito's opinion tentatively to stay signed on, or it could be that one of the liberal clerks or liberal justices leaked it as a sort of protest outrage to what Justice Alito's opinion said and did, or it could be some employee at the Supreme Court who somehow managed to get hands on the draft opinion. It's all speculation. I just don't know. Well, I mean, I think the most important thing is that if the opinion does become the law, that means that the abortion issue returns to the states, which means it would be up to the state legislatures whether or not to prohibit abortion. There are several states that have trigger laws in place so that they would automatically ban abortion if the court overturns Roe, and those laws would automatically go into effect. But then there are other states like Nebraska where it would be up to the state legislature to decide what to do. So that would be the next step. So, presumably we would have a landscape where there's some states that would definitely ban abortion, other states that would definitely preserve abortions, and then probably some states in the middle where it would be quite a deeply contested political fight.